PNC News First is presented by the Bank of Guam, the People's Bank. Pizza Hut, we're taking pizza to where it's never been before. Taco Bell, the only place where you live Moss. Colgate, the #1 brand recommended by dentists. And IT&D.
PNC News First, broadcasting live in high definition from Tumon, Guam, on KEQI and KTGM, and on KPPI on Saipan. Here is your PNC News team.
Hafid and good evening. You're watching PNC News First. We are live from the Broadcast Center at Akanta. I'm Jolene Tovis. Thanks for tuning in. Topping our newscast tonight, documents filed in Saipan District Court have revealed who the FBI was looking for and what they were investigating when they raided government and casino offices last week in the CNMI. The revelations are reported in today's Mariana's Variety. They surfaced in an unsealed copy of the FBI's search warrant and grand jury summons filed in a separate personal injury lawsuit against the Imperial Pacific Casino. PNC's Kevin Kerrigan has more in this report.
According to an article in today's Mariana's Variety, the 7-page search and seizure warrant executed by the FBI in Saipan last week sought all documents, records, and property, print or digital, that may constitute evidence of violations of various federal laws, including wire fraud, money laundering, and violations of the law against donations by foreign nationals. The warrant names CNMI Governor Ralph Torres, his brothers Vincent Torres, Victorino Torres, and Joaquin Torres, along with Alfred Chiyam Yu of Mariana's Consultancy and Ron Lai Anderson of Legend Realty. The search warrant was signed by CNMI District Court Chief Judge Ramona Manglonia on November 6. The FBI executed the search warrants the following day. The Mariana's Variety also obtained a copy of a grand jury subpoena received by Imperial Pacific Records Custodian, who was ordered to provide, among other things, any and all emails, text messages, letters, notices, or other forms of communication between Imperial Pacific International and CNMI Governor Ralph Torres. Specifically, the warrant sought documents pertaining to any cash transactions or donations to the Friends of Ralph organization or to any other political campaigns. The records custodian has been summoned to testify before a grand jury in Saipan on January 1st next year. In response to the Mariana's Variety's story, the CNMI Governor's Office issued a statement today saying, "This process has been emotionally trying for Governor Torres and his family, and in collaborating with this process and the investigation, time will show that these concerns of the federal government are misplaced at the very least." The search warrant and related grand jury summons have now been resealed. No charges have been filed against anyone yet. Kevin Kerrigan, PNC News First.
In other news, after the government filed a motion preventing the use of an entrapment defense in the ongoing federal case against Jotnya Mayor Jesse Blas, the mayor's legal counsel says the motion is premature and not needed. Attorney Joseph Rosano filed a motion on behalf of the Jotnya Mayor on Tuesday, saying the government's motion should be denied until such time the issues presented in the case becomes ripe for review. According to Rosano, the case continues to evolve and the investigation into the allegations against the mayor continues. Blas is accused of using his official capacity as Jotnya Mayor for his personal gain by selling cluster boxes to an FBI informant who posed as a drug trafficker. The Jotnya cluster boxes, owned by the United States Postal Service, are overseen by the mayor, who is designated to provide the mailboxes to residents at no charge. Blas was charged with extortion under color of official right and Travel Act bribery on September 18th. He pleaded not guilty to the charges. Telecommunications company AT&T has settled the debt it owes the Guam Ancestral Lands Commission for the use of the Tengisan cable station property in Dededo. While AT&T owns approximately $5.7 million in back rent from 2007 to 2019, the final amount agreed by both parties came slightly below $5 million. AT&T's lease agreement includes approximately 12,000 square meters of land, easements, and the existing cable station infrastructure. In an interview between K57's Patty Arroyo and Joe Angoku, the Commission's executive director, Angoku confirmed that they have received the settlement from AT&T but cannot divulge the final agreed amount. However, a GITA committee report in October states that the Board of Commissioners approved the settlement and lease agreements for $4.9 million at its September meeting. Angoku also says that the Commission is looking at extending the lease contract with AT&T, but the new agreement has to go through the legislature since an existing law puts a 5-year limit to commercial leases drawn by the government.
We're pretty, there's a couple of days of tense negotiations, but we were finally able to come to a middle ground, let's put it that way. But yes, AT&T is interested in going to a long-term lease, but in regards to the commercial lease law here in Guam, we are limited to 5 years, a maximum of 5 years leasing, okay? And to that respect, anything that goes over 5 years has to go down to the legislature. A request has to be made. Okay, it's got to become a law. We can't just arbitrarily go and say, okay, you can go and rent this place for 50 years.
The federal government transferred the Tengisan property to GovGuam in 2002 via quit-claim deed. That same year, GovGuam transferred the property to the Land Use Commission. Turn our eye back to crime. Whether or not Harvey Counsel will be charged with murder hinges on the decision of Superior Court Judge Arthur Barcenas, who must decide if double jeopardy applies. But either way the judge decides, the case could end up under the purview of the Supreme Court. Let's take a look. Judge Barcenas presided over two matters, a motion to dismiss and a motion to dismiss for double jeopardy. The dilemma facing the court is whether or not double jeopardy is at play with the criminal felony charge of murder, as Counsel entered a no-contest plea to simple assault as a misdemeanor at his arraignment hearing in the case. While the government argued that no plea was entered because Counsel did not verbally say, "I'm guilty" or no contest at his arraignment, double jeopardy doesn't apply. But as the motion was heard, Judge Barcenas clarified that the government was aware of the victim's passing before the arraignment hearing and questioned why the AG didn't dismiss the misdemeanor case when Counsel was scheduled for arraignment on both the misdemeanor and felony charge on the same day. Prosecutor Sean Brown told the court that the misdemeanor case was called first and that they didn't want to dismiss the lesser charge in fear that Counsel would be released without conditions and run. Counsel's attorney, Randall Cunliffe, shares a different view, adamant that double jeopardy applies because the no contest plea entered by the court is a conviction.
All they have to do is object, and the judge won't allow the court the plea to be entered. They object, say, "We object, Your Honor," and the judge is going to say, "I'm going to enter a not guilty plea." I mean, you guys are probably aware, in the federal court, there's a guy been trying to plead guilty for the longest time, and the court won't accept his plea. You know, I mean, the judge doesn't have to. You know. So, you know, it's just a scare tactic, you know, it's just, you know, crying wolf.
Brown argued that Counsel entering a no-contest plea for the assault charge was a trick used by the defense to avoid felony prosecution, a notion that Cunliffe disagrees with.
I'm allowed to do it. How's that a trick? You know, I mean, it might have been smart. I might have been smarter than they were, you know, seeing the opportunity for my client, and, you know, they bear the burden of the problem of not having dismissed the case sooner, or not having spoken up and said, don't allow him to plead no contest.
While Judge Barcenas has taken the matter under advisement, Brown stressed that the AG is concerned that if the judge rules in favor of Counsel, it would prompt other defendants to plead out to lesser included charges to avoid felony prosecution, adding that the delay in the felony indictment was not a result of bad faith on the government's part. However, they could have done better. It was indicated that the court's decision could prompt an appeal being filed with the Supreme Court. In other court news, the two men implicated in the shooting death of Keith Castro appeared in court today, and one of them is asking to be released to a third-party custodian. Thomas Taitano is accused of beating Keith Castro with a baton before he was shot. He is asking to be released into the custody of Governor Caval's former communications director, Troy Torres, and Taitano's girlfriend, Leonila Vasquez, as potential third-party custodians. Taitano would live at Torres' residence and would have his girlfriend visit the home if necessary to act as a custodian. However, that request was opposed by the government, who stated that Torres and Vasquez are not appropriate custodians because they are potential witnesses in the case. The government pointed out that an interview Torres did with Vasquez was posted on Torres' website. The court took the matter under advisement and will issue a decision at a later time. No jail time for the teen who used a slingshot to shoot pieces of rebar at individuals outside a movie theater. 18-year-old Cuddy Jotero took a plea deal with the government, pleading guilty to assault and criminal mischief, both as misdemeanors. Superior Court Judge Arthur Barcinas sentenced Jotero to 2 years incarceration, all suspended with credit for time served. Court documents state that on July 26, Jotero used a slingshot and pieces of metal rebar to try and hit people walking out of Regal Theaters into Mooning, further indicating that the entrance door to the theater was damaged. While Jotero will not serve any additional time, he was placed on 2 years probation and must complete 180 hours of community service, as well as comply with a stay-away order from the victims. Well, don't go away just yet. After the break, we'll take a look at the airport's $39 million revenue bonds, updates to the Jigo animal cruelty case, and more.